We're joined today by Attorney General Drew Edmondson. Tell us about what U.S. District Judge Joe Heaton's decision means to the lawsuit filed by the Tarrant Regional Water District.
Well, on behalf of the Water Resource Board and the state of Oklahoma, we're very pleased with the judge's ruling in this case. Essentially, it said that our statutes governing the allocations of water within the borders of this state is constitutional, and that Oklahoma has an interest in those allocations that are enforceable in law.
The general manager of the Tarrant Regional Water District says the judge did not dismiss the case. What did Judge Heaton do?
Well, Tarrant actually had several causes of action in their petition. One was a request for allocations of water from the Cache, Beaver, and Kiamichi rivers that flow into the Red. And on that, they challenged the Oklahoma statute, and this is the one where the judge's ruling was so beneficial to the state, saying that our statute was constitutional. They had another rather general request for unspecified waters somewhere in the state of Oklahoma, and that's the one where the judge says, I don't know what you're talking about, so I don't know whether to affirm this or deny it. You have leave to file an amended, more specific petition. So they did not dismiss that because we didn't know what they were talking about. So on that one, Tarrant does have leave to be more specific, to say exactly what waters they're talking about, and then we'll proceed if they do that.
It sounds as if the judge's decision isn't the final word on the Tarrant District's attempt to get access to water on the Oklahoma side of the Red River. How far could this case go?
Well, I'm certain this is not the final word, and any time you're in federal court, obviously you can go all the way to the United States Supreme Court. If they want to challenge Judge Heaton's most recent ruling, their avenue would be back to the 10th Circuit. If they want to file a new petition, then their avenue is in the district court. If they want to proceed on the applications they've already made for allocations of water, then their venue is the Oklahoma Water Resource Board. So the ball's in their court. We got a very favorable ruling defending our statutes. I am certain this is not the end of the road, but the next step is up to Tarrant.
The decision signaled that Oklahoma and Texas could work out some kind of agreement under the terms of the Red River Compact. Do you think we could come to a settlement?
One of the things that the Water Resource Board will be looking to is what are the needs of the Basin of Origin for the next 50 to 100 years. What are the needs of the rest of Oklahoma, central Oklahoma, to waters of the state for the next 50 to 100 years? And until those questions are answered, we don't know. We know that there's water that's flowing out of the state, but we don't know whether it's water that needs to be allocated within the state over the next several decades. And those are the questions that we hope are answered in the Comprehensive Water Plan.
How do you think this decision will affect the Hugo water lawsuit?
I think very obviously the sustaining of our statute will have an impact on the Hugo lawsuit. They will need to make application to Water Resource Board. Their application will be determined under the standards of House Bill 1483, and if they're denied, then they can appeal if they think that's arbitrary, capricious, or unconstitutional. But they're going to be looking at this ruling by Judge Heaton that the criteria, at least, are not violative of the U.S. Constitution.
Does this affect House Bill 1483?
Well, it sustains it. At least in this district court judge's opinion, those are not encroachments on the rights of other states.
General Edmondson, thank you very much for joining us today.